feel anxious, fear, and instant pushback.
Whenever I see the police, I always get nervous. There's this feeling that, am I doing something wrong? And I could be doing everything correct. But the fact is now I feel that my black skin is a reason for the police officer to bother me.
In Terryville, Ohio, a plainclothes police officer saw 3 men acting strangely outside a store.
Detective McFadden observed 2 of the men, John W. Terry and Richard Chilton, walk up and down the same street several times, looking in the same window. A 3rd man walked up, had a short whispered conversation, and then walked away.
The police officer then suspected that these 3 men were casing the store to rob it. This police officer then walked up to the 3 men, told them he was a police officer, and then patted down their outside coats. 2 of these men had guns and were arrested.
Terry appealed the conviction, arguing that the stop and frisk violated his 4th Amendment right to be free from unreasonable searches and seizures.
Terry appealed all the way up to the Supreme Court. And when it got to the Supreme Court, the question before the court was whether or not the stop violated his 4th Amendment right to be free from unreasonable searches and seizures. Because the 4th Amendment protects you from unreasonable invasions of your privacy and restrictions to your movement. Before Terry, an officer would need probable cause to stop you. And probable cause, that's the facts and the evidence that would lead a reasonable person to believe that a crime has been committed.
But the decision in Terry changed all of that. In Terry, the court determined that the officer conducted a reasonable search that didn't unjustly invade his privacy because it was limited in scope. The officer only patted the outside of the coats, and he did so only to check for weapons.
The court found that due to the officer's experience, the behavior of the 3 men, and the overall circumstances surrounding the search, the officer was reasonable in suspecting that criminal activity was afoot and was therefore justified in taking action.
As long as an officer can articulate why he reasonably suspects someone of a crime, he can stop that person, ask them questions, run background checks, and investigate for a short period of time. And as long as he can articulate why he reasonably believes that they are armed and dangerous, he can subject that person to a pat-down of the outside of their clothing, personal items, and compartments of their vehicle to look for weapons that could be used to harm him.
However, just as in Terryville, Ohio, that officer is limited to a pat-down of the individual's outer clothing.
Police cannot look inside your pockets or manipulate your clothing to feel for things that clearly are not weapons, unless you consent.
After Terry v. Ohio, we see a much lower legal standard for a stop. Officers no longer need probable cause to stop you because Terry created a loophole called reasonable suspicion.
Stop and frisk was ruled unconstitutional in New York because it largely singled out black and Hispanic young men.
No, you're wrong. It went before a judge who was a very against police judge.
Recently, a federal judge in New York had declared that New York's stop and frisk policy was unconstitutional due to it targeting minorities in traditionally minority neighborhoods. When a New York mayor was elected, that mayor decided to reform their policies in accordance to the federal judge's decision. However, this does not mean that the Terry stop and frisk is unconstitutional. The federal judge only stated that New York's implementation of the Terry stop and frisk was done in such a way that violated the Constitution.
So now I'm making sure that I'm sitting up straight in my car. I'm making sure that my hat is off. Or if I'm out in public, I'm making sure that I just continue on doing everything that I'm doing, hoping that I become invisible.
Your nervous feelings and fear can create suspicion and make a bad situation worse. Remember to relax and be confident in your knowledge of your rights and the law. The Fourth Amendment grants you the right to be free from unreasonable searches, while the Fifth Amendment grants you the right to remain silent.
A stop and frisk is a brief, minimally intrusive search or pat-down of the person to determine whether or not that person is armed.
Being detained is different from being arrested. Typically, when an officer detains you, it is in a public place and you are not required to relocate to a different area. The purposes of being detained is to identify yourself and to justify your activities in that particular place.
A Terry stop should be non-intrusive. Police officers should not go inside your pockets. They should only pat the outside of your clothing. If an officer squeezes and fondles the contents of your pockets, inform him that you are aware of the limits set by Terry v. Ohio.